Amid the flurry of executive orders Trump signed after taking the oath of office on Monday, a major change in our understanding of constitutional law. Now, his critics will say it's an attempt to defy the Constitution by executive action, as though that would be anything new in the context of the last 4 years. As we'll get to, I don't think that's right, though. I think it's to restore a proper understanding and implementation of constitutional law, actually. But Trump changed the executive branch's definition of birthright citizenship, as in who holds the right to citizenship by birth in this country under the 14th Amendment. Here was the moment.
This next order relates to the definition of birthright citizenship under the 14th Amendment of the United States.
That's a good one. Birthright. That's a big one.
What about that one in the court? That one is likely to be passed.
Could be. We think we have good grounds, but you could be right. I mean, you'll find out. It's ridiculous. We're the only country in the world that does this with birthright, as you know. And it's just absolutely ridiculous.
As far as the reporter warning him that this is going to get challenged in the courts, yeah, that would be the point. To get legal clarity on something the Supreme Court has not specifically addressed. On Trump's claim that we're the only country that does birthright citizenship this way, not quite. There are actually others, but there aren't many because, as he says, it is a system that's liable for abuse. The actual executive order is called Protecting the Meaning and Value of American Citizenship. After describing the purpose of the 14th Amendment's language, the policy change it makes is that instead of anyone born on U.S. soil automatically having citizenship, regardless of the legal presence of the parents or not, U.S. citizenship will not be granted when the baby's parents are not legally present in the country, or if the parents are here temporarily, like for work or school or tourism or otherwise. The second Trump signed the order, per that astute reporter's warning, the lawsuits were already filed because this move was anticipated. The ACLU and immigration advocacy groups filed federal challenges in Massachusetts and New Hampshire on Monday. It is expected that Democrat attorneys general in California, Connecticut, and likely other states will join as well. The initial filing in the ACLU suit argues the 14th Amendment plainly protects unrestricted birthright citizenship as previously recognized by the Supreme Court. So please, Mr. Judge, tell Trump he cannot do this. But for all the simplicity that the lawsuits and much of the reporting about the issue present, it's not very simple at all, actually, both the intent of the 14th Amendment citizenship language and what the Supreme Court has considered and ruled on it. And Trump's team knows that. Trump's team expected the legal challenge. It's probably exactly what they wanted because these lawsuits will get the courts considering questions they haven't considered before, probably all the way through the Supreme Court. As the language of this executive order targets, the problem with birthright citizenship is most apparent in the context of illegal immigration. Parents show up here without legal authorization, they have a baby, and that baby is now a U.S. citizen, even though mom and dad had no right to be here. Is that actually what the 14th Amendment intended? Now, the current understanding is yes, or at least it was, but that understanding of constitutionally commanded birthright citizenship for the children of illegal immigrants has messy legal origins. The 14th Amendment's language is far from clear in compelling that. There is no Supreme Court decision that compels that. The court has made decisions on matters that are adjacent, and those are relevant, but they have never definitively said the children of illegal immigrants are citizens through the 14th Amendment. There is no federal law that says that either. Congress has never passed such a thing. For all the current criticism of constitutionally questionable executive action from Trump on the matter, birthright citizenship for the children of illegal immigrants is itself a creation of executive action. It's just something the executive branch started doing decades ago, but legal review of it has never made it to the Supreme Court. So now that it's on that path, what will the courts actually consider? Well, first of all, what does the 14th Amendment say, and what was the intent at ratification? The first clause of the first section of the 14th Amendment addresses the issue. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. That has been read to mean that being born here makes you a citizen, effectively no matter what, often without consideration for that key qualifier, subject to the jurisdiction thereof. What does subject to the jurisdiction thereof mean? It must mean something if it's in there. The language isn't accidental, and it must mean something other than born in this country. Otherwise, why is it in there? A and also B grants citizenship is the clear structure of the sentence. A is born here, so B must be something else because the sentence logically wouldn't be A and also A. So what is B? Well, the Supreme Court has actually addressed that question in a slightly different context. What does subject to the jurisdiction thereof mean? And in fairness, they answered in a way that does lend credibility to the current understanding. It's just the case that they got that answer wrong is pretty strong. In 1898, the Supreme Court decided the case of U.S. v. Wong Kim Ark. Ark was a Chinese man, born in San Francisco in 1873 to Chinese parents who had legal residence in the U.S. but not citizenship. In 1889, Ark returned to China with his parents. The next year, he came back to California, but his re-entry was disputed on the claim that despite his birth here, he was not, in fact, a citizen because his parents were not citizens. Eventually, the case was challenged to the Supreme Court, and the Supreme Court decided that language, subject to the jurisdiction thereof, means subject to the laws of the country or required to obey the laws of the country rather than subject to a foreign power, in this case, the Chinese emperor, which the dissent argued was the proper understanding of the clause. But the dissent didn't have the numbers, and the case was decided 6-2, with one justice abstaining. And so Wong was a citizen under the 14th Amendment, and the clause, subject to the jurisdiction thereof, has been understood to mean subject to the laws of ever since. But that understanding has some problems. Primarily, it's nearly duplicative, as in being here and being subject to the laws here are nearly the same thing. Who is here and is not subject to the laws here? There are very few exceptions. Foreign diplomats, primarily, and their families who enjoy diplomatic immunity while here, so they are not subject to our laws, and if they have children here, those children are not citizens. The only other situation would be the children of foreign invaders in a war, the court reasoned in that decision, though of course the question then follows, if the children of foreign military invaders aren't citizens, then why are the children of foreign civilian invaders coming on foot from the South? But that brings us to the natural question, what did the authors and the ratifiers of the 14th Amendment mean when they wrote it and they passed it? Did they actually mean that anybody born here is a citizen with just these very narrow exceptions? Because the history is actually in conflict with that understanding. Congress passed and the states ratified the 14th Amendment after the Civil War with the intent of extending freed slaves and their children citizenship. Now, that doesn't mean there aren't other applications, but of course, that was the primary application. The thinking was not anybody who comes here and has a baby automatically gets citizenship for that baby. How do we know? Look at where the language came from. The subject to the jurisdiction thereof language came from the 1866 Civil Rights Act, Congress's attempt to bring citizenship to former slaves before the 14th Amendment's ratification by the states 2 years later. And notably, that law says citizenship is granted to people born here who are not subject to any foreign power. That language was changed to subject to the jurisdiction thereof in the text of the 14th Amendment, but that is a significant clue about what Congress meant with that language. It was not subject to the laws of explicitly at the time. It was subject to a foreign power, as in, if you show up here as a citizen of a foreign country and have a baby, that baby is not automatically an American citizen. It is the subject of a foreign power. And if that's not what Congress meant with the 1866 Civil Rights Act and the 14th Amendment that followed, why did Congress act as though it was for decades after the fact? Notably, American Indians and their children did not become citizens of the United States until Congress passed the Indian Citizenship Act of 1924. Why would Congress have passed this law if the proper understanding of the 14th Amendment is that anybody born in the U.S., even to non-citizen parents, is automatically a citizen? It's probably because that was not the understanding. The understanding was the tribes were separate sovereignties, and so children born to tribal members were subject to that jurisdiction thereof. And therefore, under the 14th Amendment, those children were not automatically citizens of the United States. Congress would have no need to pass that law if Congress's prior intent was anybody born here is a citizen. It would just be saying the same thing all over again. Okay, well, even if the Supreme Court did get it wrong a century and change ago, isn't that still the precedent? Only kinda, actually. Technically, the facts in the holding in that Ark case are a little different. Remember, Ark's parents, though not U.S. citizens, were in this country legally. These days, people not legally in this country are having babies here, and those babies are given automatic citizenship, and that is what Trump's executive order is looking to limit. And would the Ark case have been decided differently if his parents were illegal immigrants instead? It's a good question to consider. The decision made specific reference to his parents' legal presence, and it was a presumed part of the holding. Legal presence is a repeated premise in the text and the reasoning of that decision. And thus, it's not just interesting to wonder what might have happened if that key fact was different. It means the holding in the case may be dependent on or limited by that fact. Does the Ark decision give citizenship to the children of illegal immigrants, or does Ark only apply to people who are here legally? The Supreme Court has never decided. The closest the court has come is the 1982 decision of Plyler v. Doe, in which the majority has said there is no plausible distinction between documented and undocumented immigrants in regard to jurisdiction, assuming subject to the jurisdiction thereof means subject to the laws thereof. But that was a case about illegal immigrants' access to public school. It was not about citizenship. And that particular quote was dictum, as in commentary within the case, but not the legally binding holding of the case, meaning the issue is, in fact, prime for original Supreme Court analysis. So when that reporter warns, oh, that's going to be challenged in court, yeah, and it should be. So the Supreme Court finally clarifies whether the constitutional language that's cited to mean that we have to give the children of illegal immigrants citizenship actually means that, or if it's just been a big mistake the whole time. Because there have been many mistakes the entire time. Roe v. Wade was constitutionally wrong for its entire 50-year time, as decided in 2022. Chevron deference to executive agencies to write law by bureaucracy was constitutionally wrong for its entire 40-year time, as decided last year. Separate but equal was the 14th Amendment equal protection standard for more than half a century, until it wasn't anymore. Point being, just because we've done it that way for a while, or maybe even a very long time, does not mean that it's constitutionally correct. In fact, very often, those two things are completely opposed. And birthright citizenship for the children of illegal immigrants very plausibly fits neatly into that same category, a constitutionally incorrect interpretation that has just stuck around for a while. And those things are on a bad run lately, falling even faster than the last remaining justices scrambling to uphold them. Speaking of, how long does this frown have to droop any further? Though, I guess, in fairness, old saggy frowns do survive to hang pretty low in that town. So, who will even be deciding this case when it gets to the Supreme Court is another important question to consider. As always, minority women, hardest hit. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X. That is at ML Christiansen. You're always welcome to coming out and chatting my live streams. Those are live on Wednesday and Sunday nights. Looking forward to it. Goodbye.